There has never been a Supreme Court decision that has reversed a fundamental right that has existed for 50 years. To understand how radical the Dobbs decision is, to put it in that context, that the Supreme Court has never done something like that. They've never taken away a right. They have granted rights that people have not necessarily had before, like the right to gay marriage, but they have not taken away a right until Dobbs.
Something that we know is very hard for most people to understand is the Constitution. You'd think it's simple and probably feel like it's drilled into your head forever, but there's this thing called supremacy in the law.
And what that means is that federal law, and specifically the federal Constitution, always supersedes state law. And ever since Roe v. Wade was overturned, states have become increasingly emboldened to restrict abortion and make new rules to make it harder to get an abortion.
And so on our show, we'll intermittently refer to Roe, which was the case that guaranteed reproductive health access through viability or abortion access through viability.
And Dobbs, the court case in which the Supreme Court was asked to reconsider that federal right to abortion and overturned it.
So yeah, there was Roe for 50 plus years, and then the Dobbs decision made that null and void.
When people talk about the overturn of Roe v. Wade or talk about the end of Dobbs, they often act as though there's some, bright red line in terms of how people receive abortion care. And what we know is that what's happened next has sort of been a Wild West. Many states have started restricting abortion and making up new and very, very wild laws to make it harder to get one, while other states have moved to put in new protections to make it easier to access abortion in those places. The rules are all over the place. They're really hard to understand. They're really hard to remember. We can't even remember what the rules are in the states next door. It turns out that having a national right to something, like the right to vote or the right not to be owned by someone else, is a really important framework on which state laws are based, or at least boundaries for how far state law can go.
So we sat down with Bridget Amiri, who's a lawyer for the ACLU, to hear about how the law works now that no one authority is really in charge.
My name is Bridget Amiri, and I'm a deputy director at the ACLU's Reproductive Freedom Project, and I've been litigating reproductive rights cases for over 20 years. I wasn't exactly sure what I wanted to do when I grew up. I'm not sure that there's any kid that says, I want to be an abortion rights attorney when they grow up. Maybe there is. But, I grew up actually wanting to be a professional dancer. And when I realized that wasn't going to happen, I knew that I wanted to do something to make change. I wanted to have some sort of tool for social change. And the mother of the kids I grew up babysitting for in Ann Arbor worked at Planned Parenthood, and I was exposed to that piece of things, and I was very pro-choice, and my mother is very politically active and aware. And so when I went to law school, I tried a bunch of different things, and there are a lot of things I was very interested in, but reproductive rights just spoke to me so much, because if we don't have the ability to make decisions about our body, then we can't be equals in society. The constitutional underpinning of Roe versus Wade primarily is the right to privacy in the Constitution under the 14th Amendment. And it is a right to privacy in bodily autonomy, and also your right to make decisions about your body as well. So that was the general underpinning. And Roe versus Wade built off of prior precedent, including the Supreme Court precedent that found that it is a right to privacy to use and access contraception as well. So it is a logical conclusion for the court to find a right to privacy in the context of abortion after finding it in the context of contraception. It really all depends on who is sitting in those Supreme Court justice seats. And as sad as that sounds, it's true. And unfortunately, the results were outcome determinative in Dobbs. They had a mission to overturn Roe versus Wade. President Trump vowed to appoint Supreme Court justices to overturn Roe versus Wade, and they did. I'm a litigator. I go to court, and we have trials in a lot of our cases, and we also argue the appeals. I see the case from the very beginning to the end, which may be the U.S. Supreme Court, it may be a state Supreme Court, it may be an intermediate appellate court. The other side is the state, usually.
Jonas, where do people learn about laws and the Constitution and all of that? Like, how do Americans know about this process?
I think it's in high school civics class, don't you think?
That's where I first remember learning about it and talking about it. And
Do you remember your civics teacher?
yeah, I mean, he was awesome. I mean, he was like so animated about it, like really had a good grasp and understanding.
Yeah, I think mine was also the tennis coach, maybe the women's tennis coach.
Yeah.
So focused quite a bit on Second Amendment rights and concealed weapons. I don't think he had a concealed weapon in the classroom, but hard to say, you know.
Well,
It's the South.
yeah.
But what Bridget is talking about is state laws, federal laws, state courts, federal courts. And I think that this gets pretty confusing for me, at least, and has caused me to go back to that video, How a Bill Becomes a Law, a few times, both to understand what the process is and...
I'm just a bill.
Only a bill, and I'm sitting here on Capitol Hill. Well, it's a long, long journey to the capital city.
We often have very short lead times to argue. I keep a suit on the back of my door in my office, which I've had to grab, including a pair of court shoes underneath my desk, to jump on a train to Washington, D.C. to go into court and argue with almost no notice. So it can happen very fast because time is of the essence in our case, especially when we're talking about an individual. But even if we're talking about just trying to keep clinic doors open or reopen them, every day matters. Every day they can see patients makes a difference for those people's lives. So we try to move very, very quickly. So we're often operating with very little sleep. We are working around the clock. And in terms of how things go, it really just depends on the court and the judge. When we have an evidentiary hearing, a trial where there are witnesses, for example, we usually have more lead time, and we try to tell the story to the judge. We don't have juries deciding the cases, it's the judge, but the judge is the finder of fact. The judge will make determinations of credibility of the witnesses, resolve conflicts of the evidence, and we often have battles of the experts. And this is also why it's so important for the science to be cutting edge and airtight, because that gets challenged in court.
So how does a Supreme Court decision like Roe v. Wade connect with how a bill becomes a law? This all goes back to our civics lesson, or civics that we had in high school. Remember, there's three branches of government. There's the legislative branch that passes laws. There's a judicial branch, which evaluates whether those laws are constitutional. And there is the executive branch, which is the president or governor, depending on whether you're talking about state government or federal government. So states are passing these crazy abortion laws, which say you can't have abortion in all of these circumstances, or you have to stand on your head to have an abortion. And Bridget, like a legal abortion superhero, flies into that state and challenges that restriction in court and says, wait a minute, that restriction is in conflict with this constitutional principle. When Roe v. Wade was in place, the constitutional principle was privacy as articulated through Roe v. Wade. Now that that's not in place, they're more often relying on provisions of state constitutions, which may be consistent with guaranteeing a right to abortion in that state, depending on how the judges interpret it.
There are about 12 states that have banned abortion entirely, and a few more that banned abortion at 6 weeks in pregnancy before many people know they're pregnant. And some of those states are incredibly hostile and aren't just content to have their abortion bans, but they are also trying to prevent people from leaving the state to access abortion in states where it's legal. in Kentucky, when we weren't sure when Dobbs was going to be decided. You never know when a Supreme Court case is decided. But in Kentucky, when Dobbs was decided, we knew that Kentucky's abortion ban would spring into place immediately. And our Kentucky client had consented patients. They were in the waiting room waiting to be seen, and Dobbs was decided. And they had to turn all the patients away. And patients were crying, staff was crying, and it is just terribly upsetting to think that these people who had made the decision to have an abortion, the provider is willing to provide the abortion, and to have a court case say that you can't get the care that you need and you don't know when you'll be able to get it is really, really upsetting. For Kentucky in particular, we then rushed to state court, and a few days later we actually got an injunction in state court, and we were able to block the abortion ban, and the clinic was able to call the people who had been in the waiting room and said, we can now see you, come back, and we were able to restore care in Kentucky for about 4 weeks before we lost the injunction again. So, and we haven't gotten it back. We lost our challenge for now. So it's this roller coaster ride, this ping pong game with people's lives that is just heartbreaking for the clients, for the patients in particular, and just life changing for people who can't get the care that they need. So Ohio has been one of the most restricted abortion states in the country for many, many years. And it's a combination of state legislation and also the Ohio Department of Health creating barriers for abortion providers in this shell game of constantly changing requirements. So it's a combination of the two. But the Ohio constitutional amendment guaranteeing reproductive freedom really allowed us to challenge not just the things that were of immediate threat, like a 6-week abortion ban, which we had actually started before the constitutional amendment was passed, but to go back to these restrictions that had been on the books for years and years and years that we had not been able to challenge, like a 24-hour waiting period, 2-trip requirements. So someone would be forced to go to the clinic one day and then come back 24 hours later after this waiting period and bias counseling. And we were able to get a court to block that so that there is no 2-trip requirement and there is no waiting period. And what that means for people in Ohio is that they're able to be seen on the same day, and also people coming from Kentucky don't need to make 2 trips. So these were old restrictions on the books for many, many years, but this new tool of this constitutional amendment gave us the ability to wipe that off the books. So we have lawsuits in Idaho and in Alabama challenging threats by law enforcement to say that in Idaho, providers can't refer patients out of state where abortion is legal. And in Alabama, the Attorney General has said that it's criminal activity for someone to help another person get across state lines where abortion is legal. So the amount of hostility, again, these states are not content to just have their abortion ban, which is bad enough as it is, but trying to prevent their citizens from leaving the state to get abortion where it's legal. Obviously, that's blatantly unconstitutional. We've got another set of constitutional norms which say that there is a fundamental right to travel. There's a fundamental right to free speech, which includes talking about where you can get an abortion out of state, where it's legal. So we have those cases ongoing. We've been very concerned with the criminalization of abortion from the provider side, from the individual side, from the helper side, someone helping someone get access to abortion. And so we have created this network where if you are seeking legal advice, there is one central place to go on the Abortion Defense Network's website, and there's a form you can fill out, and then it gets sent out to the proper organization or pro bono law firm. We have a whole bunch of pro bono law firms on tap because we don't want anyone to not have the proper criminal representation or criminal advice. So this also comes up in the context of health exceptions to abortion bans. And so this was a feature in our Georgia case as well. And so we also had psychologists and other doctors who work with pregnant patients who are in mental health distress because of their unintended pregnancy or a very wanted pregnancy, but there's been some mental health crisis that has led them to the decision to terminate. And so a lot of the health exceptions or medical emergency exceptions to abortion bans are written in a way that excludes mental health. It says only if there's a physical reason why the patient needs an abortion immediately or to preserve some bodily function, and it's to the exclusion of mental health. And our witnesses testify that, for example, some patient who experience extreme postpartum depression, suicidal ideation after their prior pregnancy, that they don't want to have to go through that again, that pregnancy also may kill them in a way that is different than an infection or an hemorrhage, but it is just as serious, and we should be treating it just as seriously as a hemorrhage or an infection, the psychological impact on a pregnancy and mental health distress. So we had great testimony in this trial in Georgia, and the lower court judge, wrote a fantastic opinion about why are we treating these two things differently? Haven't we made progress in this country of taking away the shame and stigma of mental health issues and treatment, and so why are we treating the exception to Georgia's 6-week abortion ban differently if there's a physical risk to the patient's health versus a mental health risk?
Let's read a little bit from the judge's decision. He says, "For these women, the liberty of privacy means that they alone should choose whether they serve as human incubators for the 5 months leading up to viability. It is not for a legislator, a judge, or a commander from The Handmaid's Tale to tell these women what to do with their bodies during this period when the fetus cannot survive outside the womb, any more so than society could or should force them to serve as a human tissue bank or to give up a kidney for the benefit of another. Considering the compelling record evidence about the physical, mental, and emotional impact of unwanted pregnancies on the women who are forced by law to carry them to term, as well as on their other living children, the court finds, until the pregnancy is viable, a woman's right to make decisions about her body and her health remains private and protected, i.e., remains her business and her business alone. When someone other than the pregnant woman is able to sustain the fetus, then and only then should those other voices have a say in the discussion about the decisions the pregnant woman makes concerning her body and what is growing within it."
So the judge again was convinced by our expert testimony, which was spot on, and unfortunately, the Georgia Supreme Court blocked that ruling, and we're waiting to have our day in court in the Georgia Supreme Court.
I mean, I've gotten a little numb to it.
Yeah.
But, so Georgia was a very important state for access in the South. And so when the ban went into effect there, many of the Georgia patients were scrambling to figure out where they could find care. And it seemed like such a relief. I mean, the ruling that the judge wrote was tremendously affirming for me in terms of finally a judge sees what's going on here and is thinking about this in the right way.
Basically, the judge was fierce in his ruling that, women shouldn't be grouped together as people who lose their liberty and their rights over their body of a pre-viable pregnancy. And I think the whiplash of all these rulings, it's like, a ban goes into effect and then there's a fight to stop the law and then it comes back again, and it's hard to keep track of. It's hard for providers who are starting and stopping services. Most patients don't necessarily understand what their own state's abortion law is like until they are seeking care and realize, oh, I can't have care here anymore.
So I will tell you maybe about the 3-week trial that we had in Alaska. We challenged the prohibition on Medicaid coverage for abortion in Alaska state court, and we had a trial. And at the start of the case, the judge said that he thought he could draw a line between, quote, medically necessary abortions that should be covered by Medicaid and, quote, elective abortions that should not be. And our theory was all abortions are medically necessary. Pregnancy is inherently risky. Anyone who decides to have an abortion to avoid those risks, that's a medically necessary abortion, and it should be covered by Medicaid, just like all other essential healthcare is. And so our job at trial is to explain to him through various experts why that line doesn't exist. And so we had a number of wonderful witnesses, including psychiatrists who work with women who are experiencing mental health crises as a result of their pregnancies, and to explain the mental health impact on unwanted pregnancy, unintended pregnancy, and the need to be able to have an abortion, and how that's just as valid of a reason for someone who is getting cancer treatment and is deciding to have an abortion. And so we told these powerful stories through our experts about the need for abortion in all of these circumstances. And it was an intense trial in Anchorage, and so all of our experts had to fly there, and they did an amazing job. And at the end of the case, the judge wrote an opinion, and he said, at the beginning of the case, I thought I could draw a line between medically necessary abortions and elective abortions. And after listening to all of the witnesses, I can't. The line doesn't exist. So that was really satisfying. We did our jobs. We did our jobs with the experts, and we have secured Medicaid coverage for people who have Medicaid in Alaska as their health insurance to be able to access abortion, and that victory stands to this day. So that's really exciting. There are definitely beacons of hope, and we have the power of the people. One of the things that is really evident in these last couple of years, something that we always knew, but we definitely see way more evidence of that now, is that people support the right to access abortion in large numbers, and people in states that people would not expect. So I think that is really buoying, and certain states have become real havens for abortion access that you wouldn't necessarily imagine, like Ohio I mentioned, but then also the obvious states, the Massachusetts and California and New York. And in New York in particular, there is innovation to ensure that people have medication abortion at New York City health centers for free. So really removing financial barriers to access too. So if you have a state that is a haven for abortion access, there always can be better access. So how can you have providers in more places, telehealth provision of abortion, free abortion, and I think that's the next level, and we're seeing some of the really progressive states do that.
Opinions expressed on this podcast are our own. Philanthropy is helping us highlight these stories, and we hope you'll continue supporting this work by subscribing and sharing the show and getting involved in your local community. This podcast is executive produced by us, Dr. Beverly Gray, Dr. Jonas Swartz, and Jane Marie. Production by Little Everywhere. Thanks to Nick Thornburn and Patrick Ford for our score, and Jamal Walton for original artwork. Extra special thanks to everyone who lent their knowledge and voices to the show.
Thank you.